We just wanted to tell you a little bit about us and our firm. My name is Marianne Frank, and this is
Courtney Podkowa.
Yeah. We're at a firm in Arlington Heights. There's about 17 attorneys here, and there's three big areas that we have. So you're going to hear about one of them, our estate planning and probate and trust administration department. But we also have a real estate department that does both commercial and residential, and we have a corporate department that helps businesses throughout any type, whether it's setting up the business or managing the entity. So we'll get into a little bit about ourselves. Courtney, I'll let you go first.
Sure. And today we'll go over the title. So we're doing myth busting, myths and facts of estate planning in Illinois. So this is an Illinois focused presentation because that's the state we're in. So as Marianne mentioned, I'm an attorney here at DKM&O. I've been practicing in the areas of estate planning and elder law for my entire legal career. And I've been in Arlington Heights for a little bit over 10 years now. So estate planning is obvious. Probate and trust administration, that's helping families with administering estate plans after a loved one has passed away. And then elder law is the area of law that helps senior citizens and people with disabilities with their special and unique needs.
So like Courtney, I'm one of the partners here at DKM&O. I'm one of the attorneys here, and I have been practicing in this area for the entirety of my career as well. We have a really good team. A lot of the attorneys here, we work together on a lot of files and collaborate, so we feel really lucky to have the team here. And as Courtney mentioned, estate planning, that's, I think, the more obvious one. We'll talk to you about what is a power of attorney, a trust, a will, and then the administration helping families in some difficult times. So we'll just go ahead and get started here.
Sure. So we have a few objectives today. So the first objective is to teach the ideal estate planning documents to have in place prior to incapacity. The second objective is to teach options for families who do not have planning in place but now lack capacity. And the third objection is to explain bad options when it comes to planning for long-term care and Medicaid benefits in Illinois. So again, these are our main objectives, but we accomplish them by going over these myths related to estate planning. So hopefully by going over these myths, you can get a sense of what's okay in Illinois and what's not okay, and what you can do for yourself or to help your loved ones. And remember, all of the myths on the following slides are false. So everything you see throughout this PowerPoint presentation is going to be a false myth. And again, we'll explain the truths behind them.
So the first myth we're going to start with is that a will is the only estate planning document that a person needs. It's certainly one of the ones talked about the most. A lot of people reach out and they want to hear more about what a will is, but there's actually several different documents that you should be aware of. So there's two different types of powers of attorney. There's a healthcare power of attorney and a property power of attorney. And powers of attorney are designed to help you while you're alive. And the goal is to have it signed before you lose capacity. Once you've lost capacity, we'll talk more about that later, then you wouldn't be able to sign any documents. So powers of attorney allow somebody else to step into your shoes to be able to make decisions on your behalf. But a will, there's also something called a revocable living trust. Those are vehicles where you can choose somebody, whether it's family or a friend, to be in charge of the administration. And there are also corporate trustees that you can name to be in charge of it if you don't have a friend or a loved one that would be able to step in. A will is also a vehicle that you can use for people that have young kids, or somebody with special needs. If you need somebody to be a guardian, you can name a guardian for anyone that would be a dependent. And a trust I'll get into a little bit more later, but a trust is another vehicle where you can have a document to name somebody to be in charge of the administration. And you can set some more parameters with a trust as far as when they can get access to the funds and protecting the funds from somebody, maybe whether they have special needs or if they're just a minor and you don't want them to get the money too young. So we'll go into that in a little bit more detail. Myth number two, the executor you name under your will has the authority to manage your assets both after your death and while you're alive. So this is false. A will is in effect when you pass away. So I talked a little bit about powers of attorney before. Those are honestly two of the most important documents that you can have. And those are really designed to protect you while you're alive. Without a power of attorney, if you do lose capacity, your family will be faced with potentially having to be a guardian for you, and that requires going to court. And it's a more complicated and lengthy process. So, the healthcare power of attorney. The healthcare power of attorney is designed so that if you can't talk to the physician, it allows somebody to step into your shoes, get access to your medical records, and really make some of those medical decisions on your behalf. And it's not necessarily only end-of-life treatment. It could be whether or not you need a surgery or a second opinion, really any type of a medical decision that you would need to make. Then there's also something called the property power of attorney. A property power of attorney allows somebody to step into your shoes to basically manage your finances if you're not able to. Myth number three, only rich people need estate planning. Um, Obviously, this is false. We have clients in all different stages of life. We have a lot of clients who are coming in at 18, they're going off to school and, they're worried about if they get sick, as a parent, once you have a young child who now turns 18, legally, physicians can't disclose any information to you without a power of attorney. And same with financial documents. So we have everything from the younger 18-year-olds to a couple that just had a baby. We talked about guardianship a little bit, right? Naming a guardian for a young child. Maybe you did a plan 20 years ago, kids are older, things have changed, and you want to, revisit the plan to see what makes sense. But really our goals are to make sure that you have peace of mind, you understand the documents that you have, and that everything can go smoothly if something happens.
So, and just to add in here, so everybody has an estate plan, whether you've created one or not. So if you haven't drawn up your own estate plan, put something in writing, then what happens when you die is that Illinois law will govern what happens with your estate. So at death, again, where most people are concerned about what happens with their assets. And if you don't plan ahead and create a will or a trust, then Illinois law dictates who is to inherit those assets. There's a few ways to avoid the law stepping in, which we'll talk about again later, by doing certain things with your accounts. But in general, if again you pass away, you don't have a will, you don't have an estate plan, and maybe you just have a bank account and you're the only person on it. If you don't have an estate plan set up, then the law again does dictate who your money goes to. So an estate plan is important for everybody, even if you only have a little bit of money. If you have a lot of money, it's important. Especially if you have certain people that you want to inherit and certain people that you do not want to inherit.
Right.
Because the last thing you want is to not have a plan in place and then for your funds or your money to go to the person you don't like or the person that you can't stand and haven't talked to in years and years. So it's important for everybody to have an estate
And kind of going off of what Courtney said too, the ability to name somebody in charge rather than leaving it for your family to fight over later. There's a lot to be said for being able to have everything laid out so that it's smooth and easy for somebody to step in. So we'll just jump into number four.
Yep, number four. So myth number four says the moment a person starts experiencing memory issues, it is too late to do any estate planning. So just because a person is starting to decline doesn't mean it's too late to put a plan in place. Typically, we would rely on a doctor's certification of capacity to make sure that the person does have the capacity, the legal capacity to create their estate planning documents. But as we all get older, everybody's memory starts to decline. We accumulate a lot of memories up there. So even now in my 30s, I don't remember everything that I did 10 years ago, just because, we're busy and so much is going on. But there's a big difference between forgetting where you put your car keys and forgetting what car keys are. So just because somebody's starting to have some memory issues does not mean it's too late to put a plan in place. It's a good idea if you do notice either yourself or a loved one starting to have some mental decline to put them in touch with an attorney, an estate planning or elder law attorney to see if it is possible for them to put an estate plan in place or update their estate plan and make sure it reflects what they want now while they still have the capacity to make those decisions.
Right. The hardest calls we get are families where they did wait and were not able to step in, right? So getting a call that someone's in the ICU and they're not responsive, it's like Courtney said, planning ahead is really important, for loved ones to be able to step in and make sure that we have a plan in place.
Mhm. And that kind of ties into our next myth about what can be done if you notice a spouse starting to decline. So this is an important myth for Marianne to cover.
Yes. So myth number 5 is that married couples automatically have access to each other's bank accounts, even if an account is owned individually. So I hear this all the time. There's a lot of confusion about, powers of attorney and why you might need one. So even if you own a lot of assets jointly or individually, there's scenarios that can come up if you don't have capacity. Again, the powers of attorney, we want to make sure that if anything happens and you're not able to manage it, that somebody else has the authority to step in for you. So, I'll give you an example that we see a lot. If you own a home jointly with your spouse, but you lose capacity, medical bills are expensive. Spouse decides that you guys need to maybe downsize to a smaller house. If you go to sell the house and both of you are on title, both of you are technically required to sign the deed. And so you can see challenges then with, does somebody have access, or so does somebody, sorry, have the authority to sign on your behalf, right? That's where the power of attorney comes in. Without that power of attorney, then your spouse would actually have to go to court to try to be appointed a guardian for you to be able to sign for you. So these barriers that you may not realize are there until stressful situation, you're trying to sell the house and panicked, what do we do? Especially those individual accounts. The other example I'll give you, a lot of people have an IRA or a 401k if you are working. So getting access to those accounts. While you're healthy, there's not an issue. You're able to call and direct what you might need to do. But if you are not able to direct anything with that account, the power of attorney is what allows your spouse to step in on your behalf if it's just in your name. And so you really want to make sure that you have that power of attorney set up in advance to allow a spouse or child or loved one to be able to step in for you.
Mhm. And married couples do not automatically have this access. So a lot of people think, oh, we've been married 60 years. We've always gone to the bank together. We always, have been doing all the banking together. I should be allowed to access her account after, even if she's incapacitated, even if she's not present. If there's not a joint owner on that account, or if there's no power of attorney in place, then no, a spouse cannot access another person's individual account. So this comes as a huge shock to a lot of people, especially in traditional families, some older traditional families where maybe only one spouse was on the bank account and managed all the bills, and the other person maybe had another account in their name. Married couples do not have any sort of special rights in regard to managing finances. The both of their names have to be on an account, or a power of attorney document has to be in place.
Right. Mm-hmm. Yeah. And, again, I see this a lot where clients, just to reiterate, they think, oh, well, we have everything held jointly. It's not an issue. There are still life scenarios that come up where even with joint assets, if your spouse doesn't have the ability to sign for you, they could be in trouble. So you don't want to just rely on joint assets as a type of plan.
So the next myth number 6, is that when a person can no longer make decisions, a guardianship is required, even if the person has power of attorney documents. This is also false. So when properly executed power of attorney documents are in place, those overrule the need for guardianship. So if your loved one has put together power of attorney documents and they're properly done, and then in 10 years, maybe they lose capacity or aren't able to make their own decisions, A guardianship is not necessary if the power of attorney documents are in place. They do have to be properly executed, though. So sometimes we'll have people come in with power of attorney documents that they've found online. Now we've even had people start preparing them using AI or ChatGPT, and uh, they are never done properly. So unfortunately, if you come in with, or people come in with forms that they've again found on the internet, 9 times out of 10, they're incorrect. They have to be proper state forms for the state where you live. So that would be Illinois for us. They have to be witnessed properly and possibly notarized properly, depending on the document. Um, so it's very important to work with an attorney to prepare your estate planning documents, including power of attorney documents, and not just do them on your own with the internet. Because again, I think it's probably, I would say there's only been one time in my legal career where somebody did a DIY estate plan and it actually worked out the way they wanted.
Yeah.
Usually unfortunately, it's usually turns out to be a flop. Again,
Right.
the internet does not differentiate between California law and Illinois law. So
Right.
sometimes you might think that you've got an Illinois power of attorney document and it's really from Nebraska or some other
Mhm.
state you've never been to. Um, so legally valid power of attorney documents for the state where you live will trump the need for a guardianship if that day ever comes.
Absolutely. So, especially if you've recently moved, I think it's always a good idea to talk to an attorney licensed in the state that you're now living in, because especially those statutory powers of attorney, it is specific to the state you're living in. So, you do want to make sure that that's current with the state that you live.
So the next myth again has to do with guardianship. This one says if a person requires a legal guardianship, the government will automatically become their guardian rather than a qualified family member. This one is also false. We hear a lot of people that from a lot of people that they're afraid that the government is going to step in and become their guardian if anything happens to them. Um, the state of Illinois does not want to be your guardian if they can avoid it, or Cook County, or whatever county you live in. If you do need a guardian to be appointed for you, then your next of kin is always notified. So your spouse, your children, your siblings, parents, there are legal requirements for notifying a person's family members if a guardianship is trying to be obtained over another person. The court does give consideration to the preference of the person. They also look at the qualifications and the safety of the alleged person with a disability, to make sure that the guardian they want is a proper fit. So again, if guardianship ever is necessary, usually a qualified family member gets gets preference. Again, as long as they are a safe choice and the judge approves of them, uh, then there's no need for the government to step in and become your guardian.
Myth number 8, the power of attorney documents should not be prepared until the agent actually needs to use them. So this is false. The best thing you can do is have a plan in place early while there's no stressors. Courtney talked earlier about having the capacity to sign documents, and really the best thing for both you and your family is to have those in place well in advance before any type of diagnosis or any stressor happens. Certainly after a diagnosis, you still can potentially sign depending on the situation, but it's better for you to have that plan in place. You can think of it like a life insurance policy. You just never know what might happen or when you might get sick. And really just having that in place gives you peace of mind, gives your family peace of mind. And not only that, everybody knows who's in charge, right? So if something comes up, the person that you've appointed as your agent knows when to step in and who to contact. So it really is important to have those set in place earlier rather than waiting until there's a stressful event and then everybody is kind of rushing. Myth number 9. So this one says it's always best to name your oldest child as executor, trustee, and agent under the power of attorney. So I hear this all the time. Parents have a hard time, when they come in, you always feel like you should name your oldest in every role. And one of the things we try to talk to our clients about is really understanding the family dynamic because for those of you who have multiple kids, you know that they all have their strengths, right? Or not, if you don't have kids, if you have friends, you know that different friends are better in different roles, right? So the goal is to pick the best person who would be able to advocate for you in that scenario. So the person you pick on the healthcare side, right? That may not be the same person who you would pick for your trust to manage the finances and the power of attorney to manage the finances. Um, so we usually try to talk to our clients to figure out who are you considering naming, and certainly if you have a kid who is not great with money, maybe they have a gambling problem or just, really not organized and wouldn't remember to pay your bills, that's probably not the person that you should be naming as the property power of attorney. It is a really big responsibility because they are given all of the responsibilities that you would ordinarily have if you have capacity. So you do want to pick somebody who would be the best fit for you.
Yeah, and you know your family and friends best. So sometimes you'll have one child who is afraid of hospitals, and the sight of blood makes them faint. They're probably not a good choice for your medical power of attorney if you have other qualified people to act in that role. Or you might have a child who has 8 children that they're driving around to everything. They're totally, so occupied. They also might not be a good choice just due to the place they're at in life. They might not be able to, help you at the drop of a hat. So again, it doesn't have to be your oldest child that's in these roles. It can be any qualified person that you know will honor what you want to have happen.
Mhm.
And it's not an honor, it's a responsibility. It's like Marianne said, it can be a lot of work. Um, and it's up to you who you want to choose for this role. So don't feel bad if again you don't choose your oldest child because you know they're not the best fit.
Right. And at the end of the day, a lot of times, I mean, the kids want what's best for you. Everybody wants to make sure you're taken care of, or your family and friends, so your loved ones. So making sure that you pick the best person for that role, like Courtney said, it's a big responsibility, whether it's the healthcare side or the financial side. So it really benefits everybody to have the right person in that role. Myth number 10. So assets owned in a revocable living trust are protected from Medicaid and are creditor proof. So remember, this is false. So just to back up a little bit, a revocable living trust, just to understand what the document is. So there's different types of plans you can create. And creating a trust, a lot of times, there's different reasons why someone might create a trust. A trust allows you to protect young ones from getting money too young. So you can set it up so that the child isn't going to be able to have access to the funds until they're 25 or 30. Same with somebody who has special needs. There's special needs trusts that you can set up to protect the funds so that they can qualify for governmental benefits and make sure that they're protected that way too. The trust then it's in existence while you're alive. It would be for your benefit while you're alive. And then when you pass away, you get to set the terms of who would be a beneficiary and who would be in charge. Um, Revocable means that when you set up a revocable trust, it means that you can make changes while you're alive. So that's the other thing is a lot of times you'll create a plan. Let's say you're a young couple, you just had a kid, you create your plan, but then kids get older, 15, 20 years later. The great thing is you can change that trust and make an amendment or a restatement to change the terms to whatever your life situation is as you get older. However, there's a lot of things that people get confused about, and we're seeing a lot of this lately. So when you create a trust, it's not creditor proof. Revocable living trust. Now, there's different types of trusts, but when you create a revocable living trust, if you get sued, the creditors can still access the funds within your trust. Um, Also, protection from Medicaid. There are many different types of trusts, but if you have a revocable living trust, it doesn't give any protection for Medicaid. Now, again, there are some trusts that potentially could give you some protection for Medicaid, but the revocable living trust, the generic trust that we're talking about, would not give you that protection. And it is important to seek out an attorney if you are concerned about having to qualify for Medicaid, or do some of that planning either way, because there are so many rules. In order to be able to qualify for Medicaid, you wouldn't want to do something that might disqualify you. And I know Courtney will get into that a little bit later. All right. So myth number 11. Joint tenancy POD, it stands for payable on death, or TOD, which stands for transfer on death accounts, are the best way to distribute assets to your intended beneficiaries. So we do see this a lot, and there's just a lot of things that we want to educate our clients on before going ahead and naming payable on death or transfer on death on all of their accounts. Um, One of the first ones that we want to educate them on is just understanding if you name, let's say, a child as a joint owner on an account, you've now tied that asset into their assets. So if they go through a divorce or if they get in a car accident and they're sued, right? That asset is now tied in as one of their assets and would be a part of that lawsuit. So you do want to be careful to make sure whether or not that really makes sense. One of the other things that we've seen too, a concern would be if you have, let's say you have 3 kids and you decide to name the oldest on the account. If you pass away, but they were added as a joint owner on the account. Now, there's a difference between owner and beneficiary, but if you name a child as a joint owner, for a joint account, that asset would pass to that child. And while your kids may all get along while you're alive, unfortunately, after you pass, sometimes things can get a little more complicated, and all of a sudden kids are fighting. The last thing you'd probably want is for that oldest child to now keep that whole large account that you had intended to pay bills and be split equally between your 3 kids. So it's really important to be careful before you start naming kids as joint owners on all your accounts to really be aware of how that would impact the plan. Even if your trust says that the assets are to be split equally, if you name a kid as a joint owner, it does not matter. It will pass according to how that account is titled, regardless of what your trust says. So part of what we do is not only making sure that your documents are in place, but we really want to look at all of the assets, how they're titled, who are the beneficiaries, so that there's no surprises later and you really understand, as a whole, how your plan would play out if something happens to you.
The other thing about naming just one child on an account and relying on them to share it with their siblings or other people is that there might be adverse tax consequences to doing that. So especially with retirement accounts, if you have an IRA and you just name one child and you say, "Oh yeah, I know they'll do the right thing," they'll share it with their brother and sister. They might want to do the right thing after you're gone, but with retirement accounts that you haven't paid taxes on yet, there can be some really bad tax consequences for them if they were to try to divvy that up later among other people. The gift tax can also come into play for non-taxable accounts too. And there's just a lot of risks with relying on either transfer on death designations or joint tenancy accounts. Another risk that we've seen happen has to do with if you have multiple accounts with people named and you have to close one, but you forget who's named on which account. So, for example, let's say you have an account at Chase that's $50,000 and you have an account at BMO that's $50,000 and you put your son on the Chase account and your daughter on the BMO account. But then you need to use some money to pay for your long-term care or some other unforeseen expense. And if you dip into the one account allocated for one child and then later on you die, it might not be there for them. And so their sibling gets a benefit. So we've seen a lot of bad scenarios happen where people rely on transfer on death designations or joint accounts where it does not work out the way that the deceased person intended it to. Another negative consequence that we've seen here, sorry, I just lost my train of thought, has to do with, I'm sorry, when your child might pass away. So let's say you name your son on your IRA, but he dies before you. All of a sudden, if you don't have a beneficiary on that account, it could go into probate, which is the court process where the court gets involved with determining where certain assets should go. Or let's say you have an account that's payable on death to your son and daughter, and your son dies before you, but you wanted his half of that account to go to his own children. If you don't have that specified in the beneficiary designation on that account, then it could all go to your daughter if, again, your son predeceases you. So there are a lot of things that can go wrong with just naming beneficiary designations or, again, children or people as joint owners. So we always caution our clients to be wary when going that route.
Right. And we're seeing, even if the form does allow you, in the scenario that Courtney just talked about, if you said, like if my son passes away, I want his portion to go to his children, not every institution allows you to actually have that scenario play out. So that's why assets like a revocable living trust might be an alternative to talk about, because you can, in the document, provide for where everything would go to make sure it goes the way you intended it. So you do have to be really careful. We've also seen scenarios where I have one right now where the client created a trust, but then really didn't fund it. And they did a payable on death with a large account and had that payout right at death to the kids. But then there wasn't enough in the trust to pay taxes. And so you get a lot of complicated scenarios where if you're planning, but don't really understand how it all works together, that's why it's helpful to meet with an attorney to just kind of figure out, does this plan make sense? Is this really the best way to do it, to plan ahead?
And so an alternative to doing this type of planning with the designations and the joint accounts is to create a revocable living trust and put these accounts, retitle them into the name of your trust. So that's what we mean when we say funding the trust with your accounts.
Right.
So the next myth has to do with your home. It says it's a good idea to add your child to your house deed if you think you will require long-term care. It's an even better idea to completely deed your house over to your children while you're alive. This is totally false. As like all the myths, this is a false one. So unless it's properly done with the supervision of a very qualified elder law attorney, you should never deed your house over to your children while you're alive, or add your children to the deed. This can cause major problems if you ever require Medicaid to pay for your long-term care. It also can cause major negative tax consequences if you add a person to your deed, or if you transfer that property while you're alive. It's just a very bad idea. So if you're even considering this, if you're worried about Medicaid, I'd say talk with an elder law attorney. If you're worried about taxes, estate planning attorney too. It can be it could have very negative consequences to do this. Adding a child to your deed also subjects that property to their own creditors again, and their own divorce. So if you add your son to your deed and he's married and he gets divorced 5 years later, technically your house is one half his, and that could be subject to a divorce settlement. So we highly recommend that you not add your children to your deed again without consulting a qualified attorney.
Right. Another point is that there are certain benefits to inheriting an asset after someone passes away rather than gifting it during your lifetime. I mean, there are certainly reasons to gift, but planning out what assets would be better to gift and understanding it, that's another reason to talk to an attorney to make sure that your kids can maybe save on taxes later, depending on how you pass that asset on to them. So really understanding all of the facts is helpful.
So myth number 13 also has to do with long-term care and planning. This says parents can pay their children under the table to act as their caregivers and still qualify for Medicaid if they need to move to a long-term care facility afterwards. So again, this is a big no-no. Medicaid is the government program that will step in and pay for a person's long-term care needs in Illinois, provided that person qualifies. So the Medicaid program has a lot of rules and restrictions on what you can do with your assets and your money prior to applying for Medicaid. So Medicaid has something called the 5-year look back. Basically what that means is from the date of application for Medicaid, they can go backwards 5 years and look at any financial transaction you've engaged in. Technically, that's over $500. So if you've added a child to a deed, if you've given your money to your kids, the state of Illinois is allowed to review that prior to determining whether you qualify for Medicaid or not. If you are paying a child to act as your caregiver, unless you have a valid caregiving contract in place, I recommend it be a contract prepared by an attorney, then you cannot pay your child to give you caregiving services. The state of Illinois, if they look back, you're trying to apply for Medicaid and they look back and see that you've been transferring cash to your children every week, and you tell them it's for caregiving, they're not going to believe you. They're going to believe that you're transferring your money away intentionally so that you can qualify for Medicaid. So there are very limited ways in which you can pay a child to be your caregiver in Illinois, at least. So the next myth has to do with gifting your assets. And I just want to clarify too, when we talk about gifting assets for tax purposes and gifting for Medicaid purposes, these are two totally different government programs and rules. So when it comes to Medicaid for long-term care, you're really not supposed to gift anything to anyone. When it comes to gifting for tax purposes, if you don't need Medicaid, that's where this myth comes in. So myth number 14, this says a person can give $19,000 per year to each of their family members and still qualify for Medicaid to pay for long-term care. Again, this is false. So the Medicaid laws are very different from the IRS gift tax laws. This is a federal tax law, the $19,000 annual exclusion per year. It does not have to do with Medicaid, and it does not mix well with the Illinois Medicaid rules. So you might hear on the news or from your advisor, hey, you can give $19,000 a year to whoever, and you'll be okay for Medicaid. That is not the case. This is not a similar law to the Illinois Medicaid law. Marianne, do you want to explain what this exclusion is?
So what Courtney's talking about is you have an annual exemption amount that you're able to gift each year. And that's typically, we see that more when clients sometimes they're trying to plan to prevent paying more in taxes later. There's different types of taxes, as Courtney mentioned. So we see that more in Illinois. If you die with more than $4 million, there is an estate tax that you'd have to file an estate tax return, and Illinois does tax your estate. So sometimes clients, when they're in their older stage of life, are kind of looking at how do we plan around this and what do we do? Or it simply could be that you're just financially stable and wanting to make gifts to your children, but Medicaid is completely different from the tax planning that we're talking about. So right now it's indexed to inflation, so it will go up, but right now you can gift up to $19,000 per person per year. So each person has this exemption that they can make that gift. So if you have 4 kids, you can give $19,000 to each of them, and it could be each person in the couple, right? So a husband can give 19, the wife can give 19. And again, I expect in the next year or two, it'll probably be going up to 20. But so a lot of couples take advantage of that gifting strategy. And what you need to be aware of is, if you are worried about if you're sick and you're spending a lot of your money on care and you think you potentially might need to go on Medicaid, you really need to be careful about how you're spending the money.
Exactly. All right. And now we're on our last myth. This myth states that all of your money and your house will go to the government if you need long-term care or Medicaid. So again, this is false. The Medicaid program, it's a state government benefit program that's run by the state of Illinois. But the state of Illinois does not get your money, and they do not get your house if you need Medicaid. Rather, what they do is they say, all right, we're not going to pay for your stay in the long-term care facility if you have your own assets and home that you could use to pay for that care. So the Illinois Medicaid program will not step in and start covering your long-term care costs until after you've gone through your own funds, savings, and potentially sold your house. So again, when you go to long-term care and you need Medicaid, again, your money's not going to the state. Rather, it's going towards paying the nursing home or the care facility where you're at for your care. Only after you've exhausted your own funds will the state of Illinois' Medicaid program kick in. So that's a myth we see a lot too. So we like to correct it when we can. And that's the entire presentation on myths.